The Legislature in Guam is back from recess. Good afternoon, colleagues. We're still on the second reading file. We are now on Bill number 293-37 COR. Primary sponsor, Senator Tello Taitagui. Senator Taitagui, you are recognized.
Sujus Masi, Madam Speaker, and good afternoon to my colleagues. Hope you had an enjoyable lunch. Madam Speaker, at this time I would like to add Bill 293-37 COR as amended by the Committee on Education, Public Safety, and the Arts as introduced by myself and Senators Joanne Brown, Senator Chris Barnett, Senator and Minority Leader Frank Bloss Jr., Senator Joe San Augustine, Senator Chris Duenas, and Senator Jesse Lujan, which is an act to add a new 58.61 to Chapter 58 of Title IX of the Guam Code Annotated relative to the use of alcohol and controlled substance within detention and correctional facilities into the third reading file, Madam Speaker, and I would like to discuss this important legislation.
Please proceed.
Thank you, Madam Speaker. Madam Speaker, it was during a public hearing that I and others among our colleagues became aware of a troubling situation in our correctional and detention facilities. The director of DOC testified that although detainees and inmates have at times been determined to be under the influence of illegal drugs or alcohol, prison officials are unable to charge them with a crime because contraband was not found. And there is no law against being under the influence while incarcerated. So as long as they are not caught with drugs or alcohol, they feel free to use them. Bill number 293-37 will provide a disincentive of contraband use by detainees and inmates by making it a misdemeanor for them to be under the influence. If convicted, additional prison time will be added to existing sentences. But the director of the Department of Correction and the chief of police testified, both the director of Corrections and chief of police testified in support of the bill. Here's a quote from DOC Director Fred Berdallo. This proposed legislation, if passed into law, may provide deterrence among the inmates and staff at the prison facilities from refraining from promotion of prison contrabands, and more importantly, using and consuming contrabands that would result in criminal prosecution and extended time for incarceration upon conviction. Madam Speaker, we know that contraband finds its way into our prisons. We know that. I was surprised, though, to learn that there are no penalties for being under the influence of alcohol and drugs. It seems that prisoners feel free to use drugs as long as they are not caught with them. This lack of repercussions undermines the rehabilitation efforts aimed at helping our inmates into society. Our corrections personnel face high-stress situations daily. Keeping detainees and inmates off drugs and alcohol will provide a safer environment for our correction facilities employees. Madam Speaker, we need stronger disincentives against drug and alcohol use in our correctional and detention facilities. Bill 293-37 provides this. I know that, Madam Speaker, there was a comment made by the chief of police from the original bill, asked that a change will be made. They recommended to remove the following phrase, the Guam Police Department, from this proposed section. The Guam Police Department is responsible for arresting individuals who may already under the influence of alcohol or controlled substance at the time of their detention. Including GPD in this context may lead to unintended consequences that detaining individuals who are already under the influence could be construed as a form of entrapment. So this was also brought to our attention, and we made this correction. So if there's anyone have any concerns about that, it's been addressed. Once again, Madam Speaker, I humbly ask my colleagues to support this legislation, but also contribute in the discussion and maybe even strengthen this law that should have been in place a long time ago. We do know, Madam Speaker, that there are other jurisdictions that have incorporated this law into their correctional facilities as well. I thank you, Madam Speaker, and looking forward to my colleagues' response or any inclusions. Thank you.
Masi. Senator, on the bill, is there anyone who would like to speak on the bill? On the bill? If not, then Senator Barnett on the bill?
All right, I know we got plenty of bills after this, so I'll just make it short. I just wanted to rise in support of the bill and thank the author for its introduction, and also my staff for the good work they did in the committee to incorporate all the concerns. You know, it is a funny thought. One of my kids, I was talking to them about this bill, and they said, "Oh, Dad, if they commit a crime when they're in jail, where do they go? Because they're already in jail." And I agree, and I know that the author had talked about possibly strengthening this bill, and I would just say that I think one of the ways we can strengthen it is by increasing the penalty of imprisonment. If the author would support that, maybe she could amend that in her close. But rise in support of the bill. The contraband obviously is a very big challenge with the Department of Corrections. And a lot of it is because of the aging facility, the severe overcrowding. I think the last count we got from DOC was 944 is the population at the Department of Corrections and the Agotnia lockup, which leads to, unfortunately, the all too common scenario where you have one corrections officer supervising anywhere from 80 to 100 inmates and detainees. And so what this does is it creates opportunities, unfortunately, for some of these people who are housed in the Department of Corrections or the Agotnia lockup to bring in contraband, to use contraband. I mean, it was reported this year that they found a gun in the prison. They've also found upwards of 100 grams of crystal methamphetamine. In that case, caught the attention of the feds. So I was also surprised, as was the author, to hear that something like this wasn't already in place for our island. So I definitely support this legislation. And again, would just ask if the author would support strengthening the penalty, the imprisonment tied to these offenses. Madam Speaker.
Senator, on the bill, is there anyone else on the bill? Senator Brown, on the bill.
Thank you very much, Madam Speaker. I also rise in support of Bill 293. You know, this issue is one of those, when the light bulb goes on in your brain moment. As a result of a public hearing, very similar to the situation when we were, through questions on the Oversight Committee with Senator Barnett, found out that public health was not doing regular physical inspections of our schools, and yet annually they were giving out sanitation and certificates. It doesn't make a lot of sense, but obviously this is a loophole that currently exists, and I think encourages, because there is no consequence to those that are incarcerated to be drunk or be on drugs in the prison. And you're assuming that when someone's incarcerated, when they're brought into what should be a secured facility, there's an expectation that these type of contraband are not going to get into the prison, but it's almost a regular thing. I remember the days, too, of DOC when they used to have the revolving door, when prisoners used to be able to get out of DOC and disappear for a day or two and maybe go back in. And I'm sure most people in the public are going, what? How can that be? Because we're assuming that if someone's incarcerated, there's some reason, some serious reason that they are there, that they did something that required them to be imprisoned. And so it's not an unreasonable expectation for the public, to which we assume we want to keep safe, that those that are incarcerated are not on drugs and they're not drinking, and if there is, and they're beyond the legal limit, then there should be a consequence to that. Because we're not seeing an end to contraband getting into the Department of Corrections, especially sometimes when you end up finding out that they're very people that are doing the law enforcement up there. And I've had friends, I've had relatives, I've had classmates who have both been incarcerated and been prisoners up there and been guards at the same time. And we all grew up together. And you got to wonder, but there it is. But the fact that there's no consequence in this particular case is concerning, and I certainly appreciate the efforts of Senator Tello Taitigui in introducing this bill, so that it's not just, it's not okay. That we don't want to see individuals that are incarcerated up there to be on drugs, illegal drugs, or to be, consuming alcohol or anything that's going to alter their state of mind that otherwise should not be happening, this type of contraband that should not be coming into the prison. We're just waiting for the next report, the next story, the next guard, unfortunately, that may be put themselves or be put in a situation where they're actually assisting in smuggling these contrabands into the prison. But if there's consequence and it's followed through with, hopefully that will discourage this sort of activity from occurring at our prison, because, this is not what the public expects, I'm sure. This is not what the people of Guam expect when someone is sentenced to serve their time for whatever crime they may have committed that has offended this community. They should not be up there on vacation and consuming drugs, illegal drugs and other substances that otherwise should not be there. So I certainly rise in support and appreciate the efforts of the author to move this bill forward. Thank you for the opportunity to comment.
Suzus Masi, Senator, on the bill. Vice Speaker, you're recognized on the bill.
Thank you, Madam Speaker. Madam Speaker, as I look at the intention of the bill and appreciate its support, I just have a question for the author, if she would yield, please.
Please state your question.
Thank you. I just would like some clarity to see if tobacco use is covered under this legislation. And since although tobacco is a legal substance for adults over the age of 21, is it still considered to be contraband at the Department of Corrections? And related to that, has the author been given any indication if there's an ability to test for tobacco? Because I know that there is a list of contraband, and I just want to make sure if that is included or not.
Would the sponsor yield to that question?
Thank you, Madam Speaker, and I thank you for that question. It is a good question. However, the director of Department of Corrections never brought that up. I didn't think it was a concern with him. I think it was a substance that can deter a person or cause them to be radical or do things that can harm another person while under the influence. And alcohol and other drugs, they're definitely in that perspective. It's the harming of their guards, as well as other inmates, but I don't think they have anything in that perspective with tobacco that they are concerned about at this time.
Okay, thank you, Madam Speaker. I just want to say that I really appreciate the answer, because I certainly support the intent of this measure. I believe our island will be safer when we take the hard line on drug use in our prisons, and because any contraband, be it tobacco or unapproved food or cell phones, harms our safety and undermines our hardworking DOC employees, and what some of those items that may not be contrabands outside is included inside. So if there is a list that is given and provided as contrabands for the prison, is there one that's provided for us to look at? Just to make sure. Because I support the intent, and I understand as stated, right, that we want to make sure that we're hard on those that are really using the drug use and alcohol use in the prisons. But again, if there's a list that was provided by TOC that is also considered, because to them sometimes contraband could be other items. Just wanted to make sure. So maybe a yield and...
Yes, would the sponsor yield to that question?
Thank you, Madam Speaker. If you look at the legislation, it says use or under the influence of alcohol, one, or controlled substance that has not been lawfully prescribed by the licensed health professional. Controlled substance, so that whether it's inside or outside of the prison, controlled substance is basically by law on what is under a controlled substance. So I don't have the list, but I'm sure we can find it in Guam Code Annotated on what's considered controlled substance.
Again, Madam Speaker, I just wanted to ensure that as we look at the intent of the legislation moving forward and the support for it, that we make sure that we delineate what was considered contraband to them, and if we needed to include it or not. I mean, if we needed to include it, that this would be the avenue for that. So, though I appreciate that the author's intent for this legislation and can support the efforts, I just wanted to make sure that we were all inclusive, if anything. So, thank you for the opportunity, Madam Speaker, to speak on this measure.
Sejus Masi, on the bill, is there anyone else who would like to speak on the bill? On the bill? If not, then the sponsor may close on the bill.
Thank you, Madam Speaker, and I thank my colleagues for their comments. I'm sure we were all pretty shocked when we heard the news that there is nothing in law that the correctional facilities can do when they find these inmates under the influence. So, and I think in both perspectives, whether they're a guard or employee of Department of Correction and the inmates, it's about safety for everyone. But I think when Guam Behavioral and Wellness came and testified and supported this legislation as well, I mean, their whole perspective is it's an opportunity for people to basically what they call dry up. And many times you hear of families saying, well, if my son or daughter can't get straight, then, you know, maybe if they go into the Department of Correction and stay there for a while, maybe they can get straight. They can clean up. And it's unfortunate that it leads to something like that. And then when you have a facility that is actually taking part of contraband or taking part of controlled substance or alcohol, addicted products, then it defeats its purpose. I do agree, though, with my good senator from Jotnya with making this a little bit stronger. 30 days may not mean very much to some of these inmates, but I guess every day of their lives sitting there it seems a lot longer than how we go through a whole week. I mean, sometimes we blink an eye and say, oh my God, the week is already over. 30 days, I thought, would be adding a heavier weight to their sentence. But I do agree that it might be too lenient at this point. So with the consent of my colleagues and their support, and without, pausing for an amendment, it's a very simple one, and that is to change from, and this would be on line 3 of page 2, to incorporate it, to strike out 30 days, and the number 30, and incorporate 90 days, in parentheses, 90. And that's my amendment.
Is there any objection to entertaining this amendment without it being in writing? Seeing no objection, we will proceed. There's an amendment to change the words 30 days to 90 days on line 3, page 2 of the bill. Is there anyone who would like to speak on the amendment? If not, is there any objection to the amendment? Seeing no objection, that amendment passes. Taitigui, you're recognized.
Sujus Masi, Madam Speaker, and again, I thank my colleagues for their support on this legislation. And one more motion, please, or amendment, is to include Senator and Vice Speaker Tina Rose Munoz Barnes as a co-sponsor.
On that motion, is there any objection? Seeing no objection, that motion carries.
Thank you, Madam Speaker, and I yield my time. Thank you.
Thank you. On the motion to place,
Thank you, Madam Speaker. So at this time, I would like to motion to place Bill 239-37 COR into the third reading file.
Bill 293,
293-37.
as amended by committee and further amended on
And
the
on the floor.
floor
Yes.
to the third reading. Is there any objection? Seeing no objection, that motion carries. We're now on bill number 327-37 COR. Vice, if you will switch with me.
We are on bill number 327-37 COR. Speaker Terlahi, you are recognized.
Sujus Masi, I'd like to move bill number 327-37 as amended by the committee and further substituted on the floor. I'd like this version to be adopted. The substitute on the floor version. This is an act to authorize the extension of the term of the lease between the Guam Ancestral Lands Commission and the AT&T Corporation for lot number 10192, Municipality of Dedido, and the building thereon. So I'd like to move the substitute version be adopted, please.
To accept the substitute version, any objection? Hearing none, motion passes. You may proceed.
Sujus Masi, I'd like to make a motion that the bill number 327-37 COR as amended by committee and further substituted on the floor be placed on the third reading file. And I'd like to speak on that motion.
Please proceed.
Sujus Masi. So, in short, this bill would authorize an extension of the lease between Guam Ancestral Lands and AT&T Corp. It's a current lease. It expires September 30, 2024. And this bill would authorize it to be extended for 5 more years. This lot is at Tengisan. So if you're looking from the beach towards the cliff, you can see this building. There's one building there, and that is where the submerged cable, where the cables come in from the submerged lands through the beach property up to that property that had been returned to the Guam Ancestral Lands Commission. The bill is quite simple, although the matter is quite complex. As you know, we are dealing with multi-million-dollar, billion-dollar industries here, where they are running cables to Guam and to other international destinations. And this particular property is not a lease for any submerged land. It's a lease for a building and a lot that had been leased by AT&T through the Department of Defense for many years. In fact, that lease was first began in 1962, and for an initial term until 1967. That included options of 9 additional periods of 5 years each and ended in October 2012. However, before 2012, it was found that in 2002 that the land was returned from the Department of Defense back to the government of Guam in July 16, 2002. So it was transferred by the United States through its General Services Agency to Gov Guam via a quitclaim deed pursuant to the Guam Excess Lands Act, Public Law 103-339. So immediately following that, when the ancestral lands learned about this in 2012, and well, in 2013, notice was given by the U.S. that the U.S. government acknowledged termination of the lease and that AT&T's continued use of the property should be addressed with the government of Guam as a current owner of the property. So in 2018, DLM did a survey of the entire leased area and designated the parcel. It consists of 12,579 square meters. And in October 2019, AT&T and Guam Ancestral Lands Commission entered into a settlement agreement for the back rent from AT&T for the period from January 2007 to September 2019. So they had a settlement amount which totaled $4,896,725.43. And as part of the settlement, they also executed this lease that we're talking about today for the property to continue going forward. So the current lease, as I said earlier, expires September 30, 2024. This was from October 2019 to September 30, 2024, 5 years. The current rent is $275,273 payable in monthly installments. GITA anticipates that the fair market value of this property has increased since 2019 and has estimated that the fair market value at that time ranged between $332,900 to $358,500. So in authorizing an extension of this lease for the next 5 years, the bill sets a minimum value of $408,000, but the Guam Ancestral Lands and AT&T have yet to determine the fair market value of the property or to determine the value of the property that will be the rental amount going forward. So this amount is put in so that payments will be made pending that final negotiation between AT&T and Guam Ancestral Lands Commission. AT&T has agreed to this amount according to their correspondence with my office, and which includes, and I'm going to quote from them at this point, it's come to AT&T's attention that under Guam Law 3499, our lease will expire if the legislature does not provide an extension. Given this information, AT&T would like to modify its request to GALC and the legislature. Instead of requesting that the legislature hold on its bill, AT&T would like to request the legislature modify the bill prior to its consideration next week. AT&T proposes to pay the proposed $408,000 per year while a fair market value assessment is performed and the new fair market rent amount is identified as per our current lease. Once the new fair market rent is determined, GITA, Guam Ancestral Lands Commission, and AT&T would then true up any over or under payments made to that date. In other words, it is determined if it's determined the fair market rent amount should have been more, AT&T will pay back rent. If it is determined that fair market rent should have been lower, GITA, Guam Ancestral Lands Commission, will be required to reimburse AT&T or credit toward future payments due under the lease the amount that was overpaid. So this provision has been included in the lease about the overpayment or underpayment, Guam Ancestral Lands Commission is in agreement with that, and I believe the Attorney General's office will be assisting Guam Ancestral Lands Commission in the negotiations moving forward. So I am very optimistic that they are going to be able to get a good value for Guam, and the beneficiaries of the Ancestral Lands Trust. So I ask my colleagues for their support in adopting this bill today as substituted. Jesus Masi.
Thank you, Madam Speaker. On Bill number 327-37 as substituted, Senator San Augustine, you are recognized.
Thank you, Madam Speaker. I'm going to ask for recess so I can review the substitute because I did have amendments that I prepared for the original bill, and being that it's changed, I got to go over all of that to make sure that it's consistent with what I intended to do. So I asked for recess.
We'll take a moment's recess. The legislature is back from recess. We are on bill number 327-37 as substituted on the floor. On the bill, Senator San Agustin, you are recognized.
Madam Speaker, I prefer that if the other colleagues can speak on it, because I have an amendment. Until everybody's spoken about the bill, then I'll speak on the bill with my amendment. Thank you.
Thank you. We will reserve your time. On the bill, Senator San Agustin, you are recognized.
Thank you, Madam Speaker. I guess nobody wants to speak on the bill. You know, the bill has good intention. I have no problem with it. But I have an amendment I would proffer, and it's on page 5, lines 17 and 18. And what it is just it identifies the GovGuam shall also require the leasee to pay all submerged license fees and annual lease as articulated in Public Law 3646 to the Chamorro Land Trust. The submerged lands and corridor used for cables to land in the AT&T terrestrial site shall be authorized to be monetized for the benefit of the Chamorro Land Trust Commission. The submerged and terrestrial properties are coupled together for the benefit of AT&T and its clients and shall be authorized for licensing and leasing as part and parcel of a submarine cable activity in Tegisan. All proceeds accrued under this law shall be for public benefit and for the programs under both the Ancestral Land Commission and the Chamorro Land Trust Commission. All other similarities situate cable landing facilities presented on island are required to obtain and secure government approval for licensure, leasing, and complying with the regulatory permitting regimes. Now, I just want my colleagues to understand, in the event, because I was advised during our recess by the authors that there are parts that are not given to us yet. It's still under DOD. But when it does get released, at least this part will apply. It's kind of like a catch-all. Today, you're on property only, you're not submerged, but tomorrow or next month or a year from now, you become submerged, then we want to make sure that the rules are there. We want to make sure that nobody gets away because it covers the bases. That's all. That's all I'm trying to do is cover the bases and be consistent what we're charging already our local industry. We want to be consistent across the board for everyone. And that's all this intent of this amendment is for. Thank you, Madam Speaker.
Thank you. On the amendment, anyone wishing to speak on the amendment? Are there any objections? On the amendment, Speaker Terlahi.
Cisus Masi, yes, and I want to thank the author for proffering this amendment, but I'm not sure I can support it, although I think I understand what he's trying to do, because during the public hearing, this is exactly what I was kind of honing in on, was it's very obvious that there are submerged cables, submerged lands, holding those cables, leading to this property that I thought were owned as well by either Ancestral Lands or Chamorro Land Trust Commission. But according to the Ancestral Lands Commission and the lease itself, the submerged lands were not returned yet by the Department of Defense to the government of Guam. So Ancestral Lands is waiting for that return. Apparently the governor has requested that land be returned, but it has not yet been returned. So that's why we made no mention of submerged lands. In fact, it would be, I think, contrary to the lease at this point, which says that this lease does not include those submerged lands. However, when the lands are returned, I would agree that we, and I'm sure Ancestral Lands is going to do the same for all any property returned to them that is submerged properties, that they are going to demand that those properties be treated at least equally to how we are treating the Chamorro Land Trust Commission's submerged lands property, and that is, to demand fair annual lease payments and license fees from these corporations. But right now, looking at this amendment right now, it's requiring that the lessee pay the submerged license fees and annual lease payments, but their lease is not with the government of Guam right now. It's with, I believe, the Department of Defense until those lands are returned. But I share the intent of the sponsor that we want all similarly situated cable landing facilities to obtain and secure government approval for licensure, leasing, and complying. And this is really one of the gaps that we're trying to close, is because while we pass a law that, sets up license fees, lease payments, it does not, and we require that they get the approval of BSP. We are, following up with BSP, and it seems like that's still not being done in all cases. I mean, it's obviously not being done in all cases, so we had an oversight hearing trying to hone in on that and make sure that we are, the government of Guam, the people of Guam, the Ancestral Lands Commission, and the Chamorro Land Trust Commission, getting fair value for all those. So they are trying to close those gaps, but for this particular property, I do not think we can include in our bill the submerged lands on this, and I think that would very much tie the hands of all the parties, because none of them owns those submerged lands, neither AT&T nor the Guam Ancestral Lands Commission. So I think the intent it's well intended, but I don't think it's consistent with what we determined at the public hearing, what we determined through the documents submitted after the public hearing from Ancestral Lands as to who owns those submerged lands and the corridors coming up to this property. But I do agree with the sponsor that we closely track the return of these properties, and that we make sure that we have in place something to deal with those properties right away and the licensing. So I would have to object to this, because this has not been run by any of the parties, neither the Attorney General, and I know when we talked about it, this was one of the things that actually, hold on. This is one of the things that AT&T particularly responded to, was my questioning at the public hearing in regards to the submerged lands. And they said, despite the existing perpetual easements establishing the right for cable runs, AT&T is open to learning more about the consideration paid by other carriers who did not have existing easement rights, and whether AT&T's lease should be modified or if other agreements should be contemplated. Accordingly, to facilitate those discussions, AT&T respectfully requests approval to continue its current lease for an additional 5 years by exercising its first renewal option, so that it may address this issue with terms that would be fair to both AT&T and Ancestral Lands Commission. Prior to that, they had talked about, we reviewed the broadcast of the hearing, took note of several related items we'd like to address. One, the current lease does not include the easement areas between the station to the shoreline, as that is private property transferred from the federal government back to the government of Guam and then to private property owners. Two, AT&T easements in those lands were stated to be perpetual and only returned when AT&T declares it no longer needs those lands. Three, the current lease does not include the submerged lands where the cables are underwater approaching the shore. And four, the distinction, there's an important distinction because the 2021 legislature referenced Public Law 3646, where it was established that cable fees are very specifically about submerged lands, not cable station property. And we confirmed with Ancestral Lands as of their records, and these statements seem to be accurate according to Ancestral Lands as well, and GITA. So I share the intent of the author, but I would have to object to putting this on the bill. I think it's going to complicate, our side of the lease. I mean, we do not control these lands.
There has been an objection to the amendment. Anyone else wishing to speak to the amendment? Vice Speaker, you are recognized, followed by Senator Blas.
My brother's smiling at me, Madam Speaker. And as I look at this amendment as proffered by my good senator from Jigo, I really just want to echo the statement made by the proffer of this amendment that maybe this provision cannot be applied right away, but it should be in law when and if it does become applicable. And, Madam Speaker, in my heart of hearts, I don't believe that we should ask something from our local companies if we don't ask the same from our off-island companies. And a lot of times that's what we do. What we have to here locally have to do, apply for, sometimes the exemptions are given from those who are coming from off-island. And to be clear, Madam Speaker, I literally want to support this efforts, but without this amendment, I don't know if I can support the bill. I want to make sure, like I said earlier, if we have to ask something from our local companies to do, it should be applied across the whole arena, not just for those that are here. It's got to be fair. And that's why I shared with the proffer of this amendment, my good brother from Jigo, Senator San Augustine, as I read this amendment, that I would support that and just bringing parity, Madam Speaker, across the board. So thank you. I support the amendment, and I want to support the bill, but I don't know if I can if this is not placed. And that's, again, about parity across. Thank you.
Thank you, Vice Speaker Munoz-Barnes. Minority Leader Blas, you are recognized.
Thank you, Madam Chair. Madam Chair, with regards to this amendment, I understand and I recognize, the desire of the proffer of the amendment. However, I think we need to take a little of a break here because as it seeks to amend the language, delete language, and then amend the language on Section 3, Section 3 is entitled Real Property Taxes. But then now the amendment makes no mention of taxes. I think we need to take a little bit of a break here because the title of the section and the body of the section don't match. And I don't think I can move forward in my discussion of this thing because if we delete the language that was under the title of the section, but then the body does not contain any of that language, is this a proper wording entitlement for this section? And what of the taxes? So I am going to suggest that we take a little bit of recess so that we can talk to the proffer of the amendment.
Take a moment's recess.
Thank you.
We are back from recess. Senator Blas, you still have the floor.
Thank you, Madam Chair. Well, you know, then I guess first off, is Proffer the amendment going to withdraw this amendment? Because if he's going to withdraw it, I won't have to speak to it.
I believe he plans to, but...
So why don't I go ahead and sit back down and let him do his course, and then I'll come back up to talk.
Understood. Thank you. Senator San Augustine, you are recognized.
Thank you, Madam Speaker. I'd like to withdraw my amendment on Section 3. And then once that's withdrawn, then I can introduce the new amendment.
On the motion to withdraw the amendment, are there any objections? Hearing none, motion passes. Please proceed, Senator San Augustine.
Thank you, Madam Speaker. My new amendment is to create a new Section 4, the applicability of Public Law 36-46. And I'll go ahead and read the whole amendment. Within 30 days of enactment of this legislation, the government of Guam shall initiate a request for a return of the submerged segment of land where AT&T cable traverses and enters Guam. Once returned, when anybody can think otherwise, when returned, but it's once returned, AT&T shall pay required licensure and annual lease payments to the Chamorro Land Trust Commission for such submerged cable landing. When applicable, the Gulf of Guam shall require the lease to pay all submerged licensing fees and annual lease payments as articulated in Public Law 36-46 to the Chamorro Land Trust Commission. The submerged lands and corridor used for cables to land in the AT&T terrestrial site shall be authorized to be monetized for the benefit of the Chamorro Land Trust Commission. The submerged and terrestrial properties are coupled together for the benefit of AT&T and its clients and shall be authorized for licensing and leasing as part and parcel of a submarine cable activity in Tengisan. All proceeds accrued through this law shall be for public benefit and for the programs under both the Ancestral Land Commission and the Chamorro Land Trust Commission. All other similarity situate cable landing facilities presently on island are required to obtain and secure government approval for licensure, leasing, and complying with regulatory permitting regimes. This is like a catch, just in case. If we don't get the property back within 30 days, or within a certain month, within 30 days, AT&T can continue on with their license. And if they never get the property back, this thing doesn't apply. But whenever they do get the property back, then this would be already in law. Thank you, Madam Speaker.
So, Masi, Senator San Augustine, on the new amendment, Senator Taitigui, you are recognized.
Thank you, Madam Speaker. I did have some concerns too. I was at the public hearing, especially when some of the land is still in the federal government's possession. Is one of my biggest concerns and question as to why is it still under the federal government, as well as some property adjacent to where the facility is at, where these cables are allowed to pass through without any charge. And then I'm finding out that is also under federal property that's supposed to be returned back to the government of Guam. There is no use for it, and hopefully that this will be done soon, because it's an opportunity for Guam to be able to get income for ancestral lands that was due to them. For many years, they've been so charged, they've been charging way under the amount that it should be compared to other jurisdictions when it comes to fiber optic cables. So I'm glad that the author of this amendment ensured that when the time comes that this property given back to the government of Guam, which submerged lands are always under the jurisdiction of Chamorro Land Trust, that we can finally be able to charge this company. And believe you, or believe me not, that you can't imagine how much millions, hundreds of millions of dollars these companies make. So it's justly so, and I'm glad that the author of this amendment recognized this one area that needs to be addressed. It would help our Chamorro Land Trust too as well. Thank you, Madam Speaker.
Thank you. On the amendment, We are back from recess on Senator San Augustino's amendment. Speaker Terlahi, you are recognized.
Jesus Masi. I like the way this amendment is worded better than the last. I still have some concerns. I'm glad that we are keeping in the bill now the provision regarding real property taxes will be paid by the lessee, and that this will be a new section. And this is really a section, it seems to be intended to govern submerged lands if they are returned. In fact, it says that the government of Guam shall initiate a request for return of those submerged lands. Apparently, according to the process that has been set up by Congress for how the governor requests return of lands and the Secretary of the Navy responds, that's already been done, and, but they did not promise to return these lands yet. And Gita testified at the hearing, to my surprise, all of a sudden, that all return of land has been put on hold. And when I asked them for documents to support that, they backtracked and said there are none. So I totally support that we are going to continue to request for the return of all the submerged lands surrounding Guam, particularly this property, which these submerged lands, which abut now private property. And so I have no problem with that part, that we are going to pursue that request. I think that the governor should absolutely be pursuing those requests for all of the properties listed in the previous table that was submitted by the Department of Defense, that these were going to be included as excess lands and that they should be returned. It's very hard to get an update on this. Everybody seems tight-lipped. And however, I think we know that as we speak, there were some properties that were recently returned and that the Department of Land Management is processing, but we have yet to see the details on those. But those lists exist, the list of what the governor has said pursuant to Gita's research and recommendations, what the governor has said should be returned, they look excess, and what the Department of Defense's response to each of those items is. And so I support that part of this amendment that says we're going to pursue the return of these submerged lands. Again, this lease does not control those submerged lands at all. However, by putting in this amendment, I am not sure how, what the legal effect of that is to on the lease, but another part of this amendment says, when applicable, meaning when those submerged lands are returned, the government shall require the lessee to pay the submerged license fees and annual lease payments. And I, of course, have no issue with that in regards to the submerged license fees. I don't, it says AT&T shall pay it. I'm a little bit wary about that because right now, whoever that land is returned to in the government of Guam, either the government of Guam, Ancestral Lands, or Chamorro Land Trust, they have an opportunity, perhaps, to bid that out. I'm not really sure. I have not further pursued that after finding out who controls the easements right now, which is the Department of Defense. So I just think, we might be a little preliminary stating that they shall pay this amount if these lands are returned to the Ancestral Lands Commission. The Ancestral Lands Commission has a new opportunity to set its license fees, its lease payments for those submerged lands, completely separate from what we're trying to negotiate under this lease for the terrestrial property, the real property on the cliffside. So they're separate, and I just worry about the implications on this short notice of including something like this. But of course, I totally support that. We want full value for these corporations that are bringing in submerged cables and taking advantage of Guam. We want Guam, if we claim we're going to be a global player in this industry, we want to receive equal value for use of our resources. And that's what we've been trying to pursue. So I fully support that. We've seen, over the years, it's really changed so fast, and it really depends on the amount of information that we're going to be able to gather. So in negotiating the terms of the lease, we're hoping to have additional resources to help us to evaluate that lease in a better way than we have done in the past. Just as we tried to do for submerged cables that we were leasing out for like $10,000 a year to now, $100,000 per cable line, per conduit, and which contains at least 6, and all kinds of other terms, $100,000 landing fees. This, in contrast to, again, those previous deals, some cables that are landing without any lease, which again, we're trying to close those up, trying to even identify whose those are. And we've got a lot of help from the industry players. So, there's a lot of competition going on. So I totally agree that we should have fair competition, and that if we're going to charge one, we should charge the other. I have no qualms in doing that. I think it's a shame that we've got some deals that are still pending here because of deals that were made in the past, such as, the lease of property down in Petey that was leased for $17,000 a year. This is the landing spot or the data center or, being used by companies. Like we brag about Google coming into Guam, but what are we seeing from that? Very little based on previous deals. So what we've tried to do by this bill is really to give the ancestral lands, together with the Attorney General's office and guidance, the utmost negotiating power and going forward. And so I have no objection to trying to make it equal. I am just worried that putting in this language in this bill without further review is going, and it's dealing with a different set of land, is going to complicate what we are trying to do with this property in particular. So in other words, they're separate, and I have no qualms in trying to come up with a formula for ancestral lands, for example, for all of its submerged lands, or something going forward when this is returned. But I just feel like adding this, it's going to look like a condition of this lease, and I'm just worried about the implications of that, because we haven't vetted that with either the AG or any of the parties, ancestral lands either. And I think ancestral lands is capable and competent enough to treat those separately. And they have an opportunity, if we leave it out, to negotiate anew for the submerged lands portion. So I hate to object, but I'm going to object to this just because of the back and forth we've been doing with the AG's office and ancestral lands and even AT&T for this one terrestrial lease. I do not want to complicate any of that with this separate submerged lands. Although I support that we are going to treat submerged lands equally. Of course, I very much support that, and I've been a #1 advocate for that in the past years. And so we're trying to get parity. We don't want those leases in the past where I think it's GTA renting for $17,000 a piece of land, or $10,000 a year for conduits coming in and submerged lands. We fixed that. So I have no intention that Guam Ancestral Lands is not going to get a good deal on if the submerged lands is returned to them as well.
Thank you, Madam Speaker. On the amendment, Senator Barnett.
Madam Speaker. I want to, I guess I'll say kindly object to the amendment. I do support, however, parity and this effort which the Chair of the Land Committee has been working hard to undertake, and that is to really get people of Guam's money's worth for these lands, especially relative to these commercial leases. Coming from the media again and having reported on a lot of Chamorro Land Trust ancestral lands, commercial leases, it's very clear that for many years, decades even, a lot of these commercial entities haven't been paying fair market value or even a fair share, really, relative to these lease arrangements. So I commend Speaker Terlahi for her efforts to really get our money's worth for the people of Guam. And I support fully everybody paying the same thing across the board, because it's going to lead to much needed revenue for entities like the Chamorro Land Trust Commission and the Ancestral Lands Commission as well. But I oppose the amendment because for me it's clear, as the speaker stated, that we're talking about lands that are not submerged. So for me, this amendment is muddying the water, pun intended, and it's a little bit of star apples and mangoes, because we're talking about, with this AT&T arrangement, lands that are not submerged, and the amendment is talking about submerged lands. And then I'm even getting texts from Ancestral Land saying, hey, Ketunadza Prim, the submerged lands are under us. So, you know, proceeding forward and over-involving the Chamorro Land Trust Commission. And the other sentiments I've stated are my reasons for objecting to the amendment, Madam Speaker. Sijos Masi.
Thank you, Senator. On the amendment, Senator Blas, Minority Leader, you're recognized.
Thank you, Madam Chair. Madam Chair, I initially rose as a matter of wanting to ensure that this language was actually separated from what I felt was necessary language in the original Section 3 of the bill. Now with the Section 4, it does address another concern that I have with regard to the language, is that in the event of, or subsequently when it does happen. So it does basically address the concern that I've had. I appreciate and I recognize the author of the bill and her concern that, this may be apples and oranges. However, what this section would provide is, in the event that it does occur, it does happen, that the laws applicable as it exists today shall be applicable to the submerged lands. Granted that this bill in its entirety, in the way it was addressed, does not address the submerged lands. However, that's a conversation that is eventually going to happen down the road if and when the government of Guam receives the property back from the Department of Defense. What this bill basically provides is the opportunity, instead of us having to come back in when that does happen, is the law that is applicable as it is today will apply to this once it is done. It's not connected to the lease agreement that the bill intends to basically address. It addresses, what it does is that in the event that the submerged land does come back, chances are it may never come back. And if it doesn't come back, this never will apply. But when it does come back, if it does come back, there is the process that's there already. Now, for us to be able to say that we're not going to be able to come back in and change it later on, that's what we can do. We've got that authority, that inherent power to be able to do that. But in the meantime, when it does happen, what this provision, what this section will provide is already the mechanism to kick in, so that there is no gap or pause or lapse in being able to address that down the road. It just says when it does come back, this will apply. In the meantime, if it's not there, it does not apply. So, and for me, that basically addresses the concern that I had with the original language when it was contained as Section 3. Now as a new Section 4, with, again, the caveat that the application of this section will only apply when the lands get returned. I'm fine with that. So I support the amendment. Thank you very much, Madam Chair.
Thank you. On the amendment, Senator Nicholas, followed by Senator Perez.
Thank you, Madam Speaker. I support this amendment because it's Joe San Augustine that authored it. Just kidding. What happened earlier today was we had an objection or a concern by the minority leader, and we walked out there and we hammered these things out and tried to make the amendment better so it's suitable. And I agree with the minority leader. I think a couple days ago, or maybe yesterday, the question was, when is a good time to do an amendment or a bill? And I mentioned back here, it's as good a time as any. This is, yes, the amendment addresses something that could happen in the future. And I was reminded a couple days ago, too, that we are the ones here that make the laws. We make the laws here. And whatever we come up with, that will be the law when the governor signs it. I think this is a good amendment. I would support the bill if this amendment passes. And I thank the minority leader and Senator Joe San Augustine for proffering this amendment. When you read into the amendment, it says, all proceeds accrued under this law shall be for the public benefit and for the program under both the Ancestral Lands Commission and the Chamorro Land Trust Commission. Anything that benefits the Chamorro Land Trust Commission and the ancestral lands is a good thing. And I rise in support of this amendment, and I thank the author and the minority leader to working this out. And in the future, should these things materialize, it was good that we put it in today. Today is a good time as any. Thank you, Madam Speaker.
Thank you, Senator Nicholas. On the amendment, Senator Perez.
Thank you, Madam Speaker. So I have a couple of questions. So again, I support that we should try to get the most from these long-term leases. And I know from the work of the Committee on Land, through the work of the Speaker, she was able to increase the lease fees from $10,000 to $100,000 per cable, and that's like six, and it holds 6, so that's $600,000 per conduit. And I forget how much conduits that can come through. So I do, I promote, getting really more for the release of these long-term leases. And so I do, I do like this comment, the part where it says, when applicable, the government of Guam shall require the leasee to pay all submerged license fees and annual lease payments as articulated in Public Law 36-46. But the problem here, though, is what if we can get more from this lease? Is there an opportunity to get more rather than what we asked for before? Another issue that I see is, do we really have true clear title? Do we know the clear title of these submerged lands and adjacent lands? So that's the question I ask of the proffer of this amendment. Do we have a clear understanding of the title of the lands that are involved in this particular amendment?
Do you yield to the question, Senator San Augustine?
Sure, Madam Speaker. If I stated earlier, when applicable, because we don't have the land, and that was clearly stated on the bill. And I understand her statement saying that maybe we can get a bigger bang. Then let's write in the amendment that we get a bigger bang later. But today, this is all we have. It's Public Law 36-46. Do we have title? Of course not. DOT still controls the property. But if it's ever and when it's released, then this applies. And at the time when it applies, whoever's in the body and states that, hey, we need to change it and increase so we can get a bigger bang, then do it then. But today we have nothing but Public Law 36-46. That's why I introduced this amendment. Thank you, Madam Speaker. I hope that suffices and answered the question.
Actually, no, because we just heard from one of the previous speakers that it's actually the Ancestral Lands Commission, not the Chamorro Land Trust. So already we don't know who the authority is. And if it's ancestral land, so the other issue with this amendment, so when you add more things to this list, there's more questions that come up, and we can't necessarily assume that what is stated is precise. So for instance, if you look at the next sentence, the submerged lands and corridor used for cables to land in the ATT terrestrial site shall be authorized to be monetized for the benefit of the Chamorro Land Trust Commission. Again, so we're making the assumption that it's the CLTC, not the Ancestral Lands Commission. So that, I think that's a question that needs to be cleared. The next sentence, so there's another assumption that I think I have questions of. Submerged and terrestrial properties are coupled together for the benefit of ATT and its clients. So how was that information gathered? Are we, again, I don't know the evidence behind that statement that they are coupled for the benefit of ATT and its clients. So remember, if it's Ancestral Lands Commission who controls this, they have the obligation to return lands, right? That's their priority as stated in many of these public hearings and confirmation hearings, that's their priority, is to return lands to the original landowner, should there be a title by a landowner. So these sentences are already kind of, I feel they're muddying the water in regards to the mission. First of all, muddying the water in regards to not really having the information as far as who has clear title. The second thing is we are imposing something that's required other of the mandate of an agency. And that is a sure way to get into lawsuits. And if, I know the intent is a good intent. We want to get the most money for this, but I think this amendment needs to be vetted or pared down quite considerably until we get that information. I'm not comfortable with supporting an amendment where we are undermining, or maybe unintentionally undermining, the mandate of an agency, as well as giving title to an entity that should not get it in the first place. Or, yeah, I think, land issues are complex. And it's, I think without any kind of, maybe committee of the whole, or to some extent, just to get to the bottom of this, what are these additional statements really, what is implied by these statements? What are we getting into? I don't think I don't have the clear picture of the impact of these statements. Again, the next sentence, all proceeds accrued under this law shall be made for public benefit and for the programs under both the Ancestral Lands Commission and Chamorro Land Trust Commission. Okay, so now they've introduced the ancestral lands now, but they didn't include it before. So there's a lot of inconsistencies in this one amendment, and to me, I don't have the information to make an informed decision to support this amendment, unless the proffer of this amendment can provide that information. And we heard from the chair of Land saying that there's still, it's unclear, right? It's unclear. A lot of these elements are unclear. And even if we investigate, there's still a lot of nuances to land issues. It's very complex. Yeah, so again, I can't make an informed decision based on the lack of information. I do support the intent that we want to get the most for our long-term leases, especially, in this heyday of an awareness of the value of submerged lands, right? I think that's one of the things I've seen is the progress we've made from a $10,000 lease for 20 years to now we're seeing $100,000 per cable. I mean, that's a huge change in progress. But I think this particular amendment, I think it could be vetted a little bit more. Or perhaps modified if we want to unless it can be explained completely. Every sentence, is there evidence to back up these things? And, you know, to what extent is an ancestral lands have title to this versus Chamorro Land Trust or a private individual? Have we done the title search? Does that exist? I don't see that information currently. Yeah, there's just too many questions for me. Masi.
On the amendment, there has been an objection. All those in favor, please raise your hand. Or would you like to close, Senator San Augustine? We're back from recess. Senator San Augustine, would you like to close on your amendment?
Thank you. You know, simple closing. The amendment is only in the event if it applies or not. What is the fear? All the reasons to question the legality if it's Chamorro or Chamorro Land Trust or if it's ancestral. Normally, then it's known. Submerged land is Chamorro Land Trust. If you don't know it by now, you've been missing a lot of the sessions. The other properties are ancestral. But we move on from there. I asked my colleagues to support the amendment. I know there's some objections, but we move on and we see where the vote stands. Thank you, Madam Speaker.
Thank you, sir. On the amendment, there's been an objection. All those in favor, please signify by raising your hand. Amendment passes. On the bill, Senator San Augustine, you are still recognized.
I have nothing at this time. I yield my time.
Thank you. On the bill, 327 as substituted on the floor and further amended. Senator Kanata, you are recognized.
Thank you, Madam Speaker. I move to place Bill 328-3.
Sorry, Madam Speaker, a point of inquiry about the number of votes for the last amendment.
Sure.
Can I just check with the clerks? Yeah, thanks. Okay, yeah, I just missed out.
On the bill, 327-37 as amended, as substituted and further amended on the floor. Does anyone wish to speak? Speaker Terlahi, you may close.
This is Masi. In proffering this bill, we had an opportunity in renewing the lease. The lease did not have to be renewed. They could have started again from scratch. We had an opportunity in renewing the lease to ensure that the Guam Ancestral Lands Commission can receive full value for this property, because we don't believe that it did when it first leased out this property. And again, as time goes on, every month, more information is able to be gathered to equip our agencies to get full value for these properties. And I do not believe in undercutting them when they're going to be the ones that are going to negotiate for the government of Guam, for the people of Guam, for the beneficiaries who have been waiting for years. We undercut them when we limit them to some deals that have been made by somebody else. Now, I understand saying maybe those would be minimum, but by saying those are going to be what this company gets, again, it perplexes me why we in the legislature are going to continue to act to curb agencies from getting full value in their negotiations. That's how we are leasing property down there for $17,000. We're leasing submerged lands for $10,000. That's how it happened. Because we came in here and instead of listening to the experts or even doing some research, we just maybe listen to one company that is a competitor, or I don't even know what. But we listen to information that really has not been fully vetted. And if we rely on the information that has been vetted, it would be crystal clear. The submerged lands are not yet returned. Of course, we should advocate for their return, and the governor should do that. She should demand that these properties be returned now. But whether we want to tie whoever receives these properties to a certain amount, we've got our eyes on it, and I don't think they can go any less than what we've required for other companies. But if they have an opportunity, such as Guam Ancestral Lands Commission would have had prior to that amendment, they would have had an opportunity to negotiate on their own for a fuller value. That is the opportunity that this bill was not trying to cut off. This bill, we went through great extents to go back and forth with AT&T, Ancestral Lands, the AG, who has to advise Ancestral Lands, dealing with an existing lease, and the circumstances in front of us to determine, to give them a fair opportunity to determine what really is the value of this property. What is the value of this property in this industry? What is the value of this property under these particular circumstances where only AT&T has easements on the land going to this property? When only AT&T has easements with the Department of Defense for the submerged lands. And maybe the intentions are good, but I don't think the rushing into adding additional terms or putting caps on the Guam Ancestral Lands Commission in regards when they're trying to negotiate this terrestrial property, putting caps that limit what they can get for their submerged lands. I don't think it's relevant. I don't even think it's germane. But I really think, unfortunately, we could have come out with a big win in here for the people of Guam, but we want to muddy that up by, I don't know what. Ancestral lands, they have challenges, but they have been watching, everybody's watching, for when these lands are going to be returned, and without binding their hands or promising it to AT&T, they had full opportunity to negotiate for those submerged lands with any company, perhaps, depending on the return. But full opportunity, definitely, to negotiate the terms of any lease with any company for submerged lands. But as to the terrestrial lease, I believe the terms as outlined in this bill are going to provide the Guam Ancestral Lands Commission with an opportunity to get what Guam maybe has not yet even received. That is a better deal, a deal more consistent with what is being negotiated worldwide, without undercutting ourselves. And it really makes me mad because, you know, we want to criticize these agencies, but when we in the legislature have the opportunity to lift them up instead of pushing them down and pushing the people of Guam down, why would we do that? We want them to get full value for both their terrestrial and their submerged lands. And we should deal with them separately. We should stick to the premise of what's in the bill, which is the terrestrial properties. You're telling ancestral lands that they're going to get $100,000 now because that's what the best terms that we negotiated at that time. But you're tying their hands for the next 5 years to those terms when we've just received information about the surrounding terrestrial properties in the millions of dollars. And I just think without adequate information, we have no business delving into that type of thing. Get the information first. And there is no rush. Unless the governors or somebody's hiding that we've got these lands returned. That has not happened according to Gita or anyone. And if we can get them tomorrow, there is still no rush because then we would own them. And then we can negotiate. And then we can set terms for ancestral lands or the government of Guam completely separate. Again, but as for the bill, I'm going to move forward because we have a deadline that we are dealing with. We have increased the amount of rent that ancestral lands is going to receive without determining yet the fair market value, and we hope that ancestral lands is going to be as aggressive as possible in getting that done, that they are going to rely on the proper experts, guidance from the Attorney General's office, and that none of those deals from the past are going to be made in closed rooms. None of the, oh, give me a cell phone or give me this or that, those types of deals are going to be made. This is a worldwide industry. We should act that way. We should encourage our agencies to act that way. It's a billion-dollar industry. We have yet on Guam, despite previous laws demanding that there be task forces, that GITA take the lead, that, these properties be valued. We just have to treat submerged lands separate from this one terrestrial property. And we need to make sure that Guam ancestral lands can, for this terrestrial property, finally get correct value. Not like what I think it was the government of Guam got in PD for its land. We couldn't find out what GTA is paying for the land over there, the Lumpang, for the giant data center that's going up. According to the lawyers, it's confidential. These things are confidential in many places, so it's very hard to get the information. So we really need to support our agencies in getting this information and getting the best deals for us. But I believe the bill as presented is a good deal for Guam. It's 5 years, and in the 5 years, they will be able to determine value, negotiate for that, and they will be able to determine whether to continue the lease as well. So I ask my colleagues to support the bill, despite the amendment.
Thank you, Madam Speaker. Motion to move the bill to the voting file. Are there any objections? Hearing none, motion carries. We are in Senator Kanata.
Thank you, Madam Speaker. I move to place Bill 328-37 as amended to the Committee of Environment, Revenue and Taxation, Labor, Procurement, and Statistics Research and Planning, sponsored by myself, Roy A.B. Kanata, and co-sponsored by Senator Dwayne T.D. Nicholas, Tina Rose Munoz-Barnes, an act to amend subsection 5707A of Article 12, Chapter 5, Title 5, Guam Code Annotated, and to amend subsection 1913C of Chapter 19, Title 1, Guam Code Annotated, relative to the procedure of the judicial review of decisions made by the public auditor in the procurement appeals and procedures of implementation of the audit recommendations by agencies into the third reading file, and I wish to speak on it.
Please proceed.
Thank you, Madam Speaker. Bill 328-37 was introduced at the request of the public auditor to address the inconsistency in the judicial review process of the OPA decisions and procurement appeals. Currently, the OPA risks being burdened by civil litigations and actions which is diverting valuable resources from its primary mission. The legislation seeks to clarify and streamline the judicial process, aligning it more closely with the procedures of administrative decisions under the Guam law. According to the committee report, this will prevent the OPA from being named as a defendant in the civil actions and reduce unnecessary litigation expenses and discovery requests, and align the review of OPA decisions with the administrative decisions in Guam. I would also like to recognize the committee chair's efforts in incorporating the requested changes in Section 3, which clarifies the procedure for enforcing recommendations made by the public auditor. And I thank the public auditor for highlighting these issues and commend him for his swift work with the committee chair, Senator Perez, and I ask my colleagues for their support on this measure. Thank you.
On the bill, is there anyone else who'd like to be heard on the bill?
Thank you, Madam Speaker.
All right, on the bill, is there anyone who'd like to speak on the bill? If not, then the sponsor, Senator Parrish, you may speak on the bill.
Thank you, Madam Speaker. So Yeah, this bill was created, actually, there was a white paper that was created by the Public Auditor's Office. And I think it was, in my meeting with them, they were joking that this would put them out of business, right? Some of the hearing officers. But, you know, and all that was all in jest. But I think the importance of this bill is that it reduces the exposure of the public auditor from having to defend their decisions. So the analogy that was given was, you know, we normally don't expect a Superior Court judge to go before the Supreme Court to act as a defendant of their decisions. And so likewise, we should treat the public auditor's administrative decisions similarly in that, you know, we should not expect them to also go before a court to explain their decisions. And so I think that made a lot of sense in this important change in the law. The other important thing about this bill was that, you know, again, the public auditors, you know, he gets a lot of questions like, how can we, you know, many senators have approached him and asked him, how can we ensure that his audits are being adhered to? And so that's the purpose of Section 3 of this bill, is to really hold the agencies to make the changes that are needed, or the recommendations that are needed or requested by the public auditor. Yeah, and I think that's something that, you know, I think as a government, you know, all these audits that have been done have been gone unheard or unresponded to. And so this bill will hopefully make a positive change in how we improve in government. So it's always important to hear the public auditors, you know, recommendations, and especially all this work that they put in. You know, it's a small office, but they put a lot of work into this. And I think it's important that it's high time that we respond to any of these recommendations. Although there are some recommendations that require political will, right? You know, there's a lot of these audits where it requires legislative action. And so that's where I foresee some issues can occur. But in general, in regards to how we operate as a government, I see that as a positive benefit. So thank you. Masi.
Masi, on the bill, Vice Speaker, you're recognized on the bill.
Masi, Madam Speaker, I promise to be real brief on this and rise in support of Bill 328-37. Certainly as a co-sponsor of the measure, as we all know, Madam Speaker, procurement in the government of Guam can be very, very lengthy, burdensome, and very expensive for all parties involved, especially when protests escalate to judicial review. I want to thank the good author from Barrigada for hearing the requests of our public auditor, and I am confident with this change we can lessen the wait times and reduce the costs associated with these procurement protests. Large-scale, complicated projects like those to build schools, power stations, highway repairs, and others can only benefit from an improvement like the one provided for in this Bill 328. I am definitely proud to be a co-sponsor of this measure and urge all my colleagues to support this bill as well. And thank the author for literally working closely with the public auditor in the committee. Sijos Masi, Madam Speaker, thank you for giving me the opportunity to speak and rise in support of this bill.
Sijos Masi, on the bill. Is there anyone else who'd like to speak on the bill?
Speaker Therese, you are acknowledged on this Bill 328. You may proceed.
And I appreciate this bill and the efforts of the public auditor to ensure that when he has to defend a decision made by the public auditor's office in a procurement appeal, that this is going to be a streamlined and efficient process. So I have no objections to any of that, and I very much support it. And I'm glad that some of the recommendations we talked about during the hearing have been incorporated by the committee. But what I really like about this bill is the part where he's trying to put more teeth behind his ability to enforce a recommendation. So right now, the public auditor does an audit and makes recommendations to these agencies, and they've been doing this for years. And some of their recommendations we might chance upon and try to incorporate through a bill and mandate agencies to do. Sometimes the agencies, if they're smart, they just take it upon themselves and they do it. But I would have to say, if we were going to count them up, that probably most of the agencies have not done that, that they've ignored the recommendations of the public auditor, and we continue to see like repeat not best practices or repeat, kind of faulty, according to their findings, ways of doing things. So I really like Section 3 of the bill that says they're going to be able to go to court directly with a writ of mandate to force the implementation of recommendations. This is huge, that the public auditor gets to force implementation of a recommendation. It's never been done before. They're going to be able to do this in the event that the governor fails to implement required corrective action plan. And I just wanted to ask the sponsor of the bill if, when we say, it says the governor, the Committee on Rules of the Legislature, or the Chief Justice of the Supreme Court of Guam. So for each of the branches, the head of the branch is going to be the one accountable in court for implementation of auditors' recommendations. Does the sponsor think that, when we say in the event the governor does not implement the recommendations, is that going to also apply to autonomous agencies where the governor claims she doesn't control those agencies? Or how do you think that is going to work? Or, for example, the Guam Department of Education, where the governor has also washed her hands and said she does not control the Guam Department of Education. Do you think this language is going to cover it? Because the auditors only recognized 3 heads of government here: the governor, the legislature, and the Supreme Court of Guam. So for the autonomous agencies, GDOE, and all those agencies that the governor claims to have no control over, do you think this language that says the governor is going to be forced to implement their recommendations is going to be sufficient?
Thank you, Speaker. Senator Roy, would you like to yield to that question?
Certainly. Thank you, Madam Speaker. I believe the language can be amended if needed, but I think it does cover all the agencies and also the autonomous agencies, because they will be dealing, again, with the auditor at the end of the day. So I think it does cover all of them, but if you want to make an amendment and add some more legal language, because that's your expertise, maybe we can get some legal counsel from our legal to make an amendment if needed, but at this time, I think it's sufficient. But if you recommend anything, I won't object to it.
Thank you very much, Senator. Speaker?
Thank you. And no, I don't recommend any change. I actually want to just point out that it's also the public auditor's opinion that the governor is in charge of every agency on Guam. Every agency on Guam. That there is no such thing as a 4th branch of government, despite the Organic Act saying the government of Guam shall do things. We've got only 3 branches of government. That's one thing. And the other thing I want to point out is, thank goodness we're going to put some teeth into these recommendations, because some of these recommendations, I am sure, would have helped us not be in the situation we are in in critical services, such as the lack of ambulances. So they're reporting today there's only 2 operating ambulances, and I got a call from Dr. Akimoto. I asked him if we could get a letter in this regard from the fire department, and he claims he talked to the chief, and the chief is telling him there are only 2 active ambulances for the entire Guam going into the weekend. Yeah, and that they're going to convert one, or they've converted one that used to carry dead bodies into an active ambulance because they're so desperate for parts. And the reason they're so desperate, I guess there are several reasons, but one of them is access to the financial management system. The new financial management system is still impairing their ability to procure these items. That's one. And I guess if the fire department loses some procurement personnel, that GSA is just not able to help them adequately. So I don't know. We'll get to the bottom of it, I hope. And but it's these type of things. If there are issues in procurement, if there's issues in repairing ambulances, and the governor cannot get that done to protect the people of Guam, then hopefully the public auditor, by going to court, is going to be able to point that out over and over and over for every agency, the critical needs that we are not addressing because we will not fix the way we do things. So I support the bill, and I really thank the public auditor for having this vetted by his attorneys, and I really think the committee did an excellent job in amending the bill as well. So I support this bill.
Thank you, Madam Speaker. Anyone else on the main motion? If not, Senator Roy, you may close.
Again, just before the 5 o'clock hour, again, thank you, Madam Speaker, my colleagues for their remarks on Bill 328. I renew my motion for Bill 328-37 as amended by the committee into the 3rd reading file. Again, I just wanted to thank the chairperson on making the swift amendments and working with the Department of, Office of Public Accountability and having this bill heard, and let's move it to the 3rd reading file. Thank you.
On that motion to place the bill 328 as amended by committee and amended on the floor to the 3rd reading, is there any objection? Seeing no objection, motion carries. We're going to recess until 9:30 tomorrow.